The IP Press Podcast. From the pens of IP Holics.
Hi everyone, welcome to the IP Press Podcast. I'm your host, and today we have a conversation that I've genuinely been looking forward to because it sits right at the intersection of two things we don't often talk about together: intellectual property and mediation. We're going to get into what it actually looks like when IP disputes go to mediation route, why most of them should, and what it actually takes to build a career that does not fit neatly into one box. We'll also touch on something close to home: what's happening with mediation on ground in Kerala, and what India's mediation movement really looks like beyond the policy conversations. And the person I'm having this conversation with today is someone who has been quietly doing a lot of interesting work across all of these spaces. Advocate Joel Kenneth Johnson is an advocate practicing before the Supreme Court of India and various high courts. He's a certified mediator impaneled through the Supreme Court of India's mediation and Conciliation Project Committee, making him one of the youngest to hold that accreditation. He's also a registered trademark attorney, a panel arbitrator with international bodies, and currently heads the knowledge and commitment vertical at Kerala Mediation Society. On top of all that, he holds an LLM from NLU Kerala and a postgraduate diploma in IPR from NLSIU Bangalore. So the academic foundation is just as strong as the practice. We are really glad to have you here, and welcome to the IB Press podcast.
Thank you. Thank you for having me.
Great. So I want to start off the conversation with something that you said earlier when we spoke, something we all really liked at the IP Press, and it struck a chord with us. You said that law school teaches us to defend, but mediation teaches us to listen. So tell me, when did that click for you? Was mediation something you discovered still in law school, or did it come later?
Uh, See, if I'm being candid with you, I think it came much later, and than I like to admit. Because when I first started law school, I was like most law students. I was genuinely believing that being a good lawyer meant having the strongest argument in the room. And everything around me at that time reinforced that idea because the moot courts that I used to attend, the classes, the internships, even the casual conversation we have in a hallway, it was an exercise to prove a point. For me, mediation was not something I discovered and immediately fell in love with. It was a gradual process, to be honest. The real shift happened when I started working, when I moved from studying dispute to actually sitting with people who were living through them. During my time handling the trademark matters, commercial dispute, insolvency matters, interacting with clients from different backgrounds, I realized that the legal issues they face are not just legal issues. Behind every file, I realized that there's a person, there's a business, there's a relationship, there's a consent, so as to say, that often never makes it to the pleading that we lawyers do. Then mediation entered the picture. I started exploring mediation more through training programs, through certification, through competition, and recently my close working with the Mediation Society. I found myself in spaces where nobody was trying to out argue the other person, so as to say. People are trying to understand what was actually causing the conflict. And I believe that was probably the moment it clicked for me. Law school taught me how to advocate for positions. Mediation taught me how to see the interest.
Right, actually, that's quite interesting because, again, I think you have again said something that's struck a chord with me is how everybody was looking at what caused the conflict and not trying to outdo each other, which actually sits at the core of not just mediation but every legal dispute. And
Yes.
looking at it through that lens helps us get beyond just trying to win and actually resolve
Yes, we
things.
learn to listen. We learn to, as I said before, as you quoted, we learn to actually understand what is actually going on beneath.
Right, that's
And
exactly
that,
right.
yeah,
Actually, and also very inspiring when you look at it through the lens of truly trying to resolve a dispute and not just run behind winning the case and getting all the money. So that's really
yes.
nice. This brings me to the next question about your exploration days. I want to talk to you about your early days because a lot of young lawyers are doing trademark filings one day, insolvency the next, sitting in mediation training on the weekend. I'm sure it's a lot. So how did you personally make sense of it all, and when did it when and all of it, when did it start making sense to you?
The honest answer is that when I was working on it, it never made sense because when I was in the middle of it, it felt completely chaotic. One day I would be preparing trademark response, and the day I would be looking at insolvency proceeding. Then weekend I would be spending as a co-arbitrator or a mediator. There wasn't a magical moment for me personally where everything suddenly made sense. What kept me going, I believe, was my curiosity because the firm I worked in, it was a one-stop solution, and I was fortunate enough to get exposure to a wide variety of matters very early in my career. I'm still in my early stages of my career. I'm only 2 years into practice, but that stage, that beginning stage, that taught me something really important. That the legal profession is much broader than the labels that we give it. Looking back 2 years, I can see how those experiences connected. I would say trademark taught me the precision that I have right now. Litigation taught me discipline. ADR taught me something that I never learned in my college, that is communication. And the leadership roles I undertook at that firm, training the interns, training my juniors, that gave me a sense of responsibility. But at that time, I was simply trying to learn as much as possible. I think that is something that young lawyers need to hear because it's okay if your journey doesn't make sense immediately. Sometimes I believe clarity comes only in hindsight.
Right, that's actually that's actually quite inspiring, and that's an advice I think a lot of us young lawyers could do is just
Yes,
stick through it and have some patience and have curiosity, because as you said, everything that you experience teaches you a lot, and that's actually a great way to put it. Because
yes.
again, like connecting it to my next question, a lot of young lawyers are told almost from day one is to pick a lane and then stick to it, either
Hmm.
litigation, ADR, IPR, or corporate. But you have
Yes.
managed to do multiple things at once, and they have also taught you a lot. So, how did that happen? And do you think that advice still applies in today, that you should specialize early?
Honestly, if you are looking at my career, if I'm talking about myself, from the outside, if you're looking at my career, it probably looks like I ignored every piece of conventional advice that was ever given to young lawyers. I have worked on trademark matters, I have worked on commercial litigation, consumer dispute, insolvency proceeding, arbitration, mediation, and now even recently, when I was pursuing my advanced studies, I was actually working within the ADR ecosystem. The truth is, I believe none of this was part of any master plan. I had not devised any master plan. I wasn't sitting in my first year of law school thinking one day I'll be combining mediation and intellectual property. One day I'll be putting ADR and IPR together. What happened to me was very simple. There was no drama there. Every time I encountered something genuinely interesting, I followed it. When I got exposed to intellectual property, I started enjoying it. When I encountered ADR, that made me curious. When opportunities came to work on mediation for me, for arbitration, or even legal awareness programs, I took them seriously. Or judging an ADR competition, I took those roles seriously. I believe specialization is important, but I also think young lawyers such as us are often asked to specialize before we have even explored enough to know what we actually enjoy. So for me personally, experience came first. The specialization is still evolving. I have not yet fixed on my specialization yet.
I think yes, that's also very important, because you need a fair bit of exploration before you can decide what is it that you want to do. Because even though when I was in law school, I decided IPR and I started doing exploring IPR, I realized that even especially with respect to academia, there's so much more in IPR that you can hone in onto
Yes.
and then specialize. And even in today's, I see a lot of discussion going on around linearity of career and how it's being encouraged more that people start having non-linear careers or explore more and more. And I think there's also, when you want to make real impact, you need to explore different things. And if you stick to one line, I don't think you're making a proper impact. But yes, your answer.
See, sticking to one line makes sense if you are experienced. But if you
Yeah,
are a youngster starting out, sticking to one line means that you don't have expertise in any other field.
right, exactly. Yeah. Thank you for that answer. Uh, the next question that I would like to ask you is around mediation. litigation has been around for a long time, and it has its own advantages such as cost, time, confidentiality. They are all well documented, and yet most lawyers default to litigation. Why would that? Why do you think that is? Is it the money? Is it the culture? Or is it something else entirely?
There's money involved, of course, but I think primarily it is a culture. Most lawyers are trained in adversarial system because that is what law school taught us. We learn how to argue, as I said before. We learn how to attack the weakness. We learn how to win. Very few of us are actually taught how to facilitate a conversation. See, litigation is very familiar. Clients are very familiar with litigation. Society understands litigation. Whereas mediation will ask people to trust a process that doesn't always look like traditional justice. I don't believe lawyers avoid mediation because they dislike it. I think many simply have not experienced what a well conducted mediation can actually achieve. The one reason I am passionate about building the awareness for mediation through organizations like the Mediation Society is because the people are very curious about mediation, but they don't know what is mediation. Some people confuse mediation with meditation, even the lawyers. More people experience mediation, I think more comfortable they become with it. Because from my personal experience, I've seen people who did not prefer mediation becoming the biggest advocates for mediation once they experienced it.
Right. So yeah, that actually makes sense because we as a society and as also lawyers are still figuring out mediation in a way as a
Yes.
root resolution. But that's that's actually a great answer to that question. So, from your experience working in mediation, especially with IP, what kind of IP disputes actually make it to mediation, and are there disputes that you think really should be coming to mediation but just aren't coming yet?
See, from my experience, the most mediation when it comes to IP dispute, it is a trademark and the branding dispute are the most obvious example that I can show that comes to mediation most often. Because business often have ongoing commercial interest. No, the clients they will be wanting a certainty, they will be wanting a practical solution. Most importantly, they want to continue operating the business, and mediation can provide that. But the category I think is seriously underrated or something that does not come to mediation often is a creator dispute in IT. Two people who have built something together, a product, it could be a brand, it could be a piece of software even. They are now disagreeing about what it is worth or who controls what. So the legal claim is often secondary to the relational fracture. No, someone feels betrayed. The wound is not about money. Even when the argument is framed that way, it might be about ego. It might be about something else. But the litigation makes it about money. The litigation can make it worse. Mediation can give us a chance how to address what's actually broken and startup disagreements, licensing deals that broke down, even technology transfer dispute. All this should come to mediation, but I have rarely seen any cases regarding that. See, the challenge in IP, not just IP, in all type of dispute, that parties often reach mediation after years of conflict. By then, their positions are hardened. It is no more about what is actually involved in the dispute, but more about their ego. The real opportunity, I believe, is introducing mediation much earlier, before the relationship is irreparably damaged.
Right. Actually, that again, that's something that's very important because when you create something together, you also put in your emotional energy, and mediation hits
Yes.
that part of your work. And
See, when you are sitting in a mediation, I believe it might be the very first time. It might well be the very first time that people actually feel like they are being listened to, that they are being heard. So mediation, I think it is way better than litigation because litigation kind of puts us in adversarial position.
right, right, yeah. So in a way, mediation is like meditation because you sit together, you talk, you try to
Yes,
get to the very root of it, you mediate with each other, and then you find out, okay, what is
yes, that
it
one will do it.
that we are heard about. Right, that's really great. So for anyone who's listening who's never actually sat in a mediation, can you just walk us through what it looks like, what happens in that room for the first session, from the first session to the point where both parties actually agree on to something?
See, most people imagine mediation as some dramatic, high stakes negotiation. In reality, from what I've seen, it is surprisingly human. You sit down, both the parties sit down, the mediator explains the process. Each party gets an opportunity to speak. And for many people, I think, as I said before, it is genuinely the first time they feel heard. The mediator helps identify the issues involved in the dispute. He clarifies if there's any misunderstanding between the parties, and then he goes to exploring the options, and then he facilitates conversation that may not have happened otherwise. Because in a dispute, I am having a dispute with my neighbor. I yell at him, he yells back. I don't listen to what he's saying. He doesn't listen to what I'm saying either. So the most fascinating thing about mediation is that solution often emerge from parties themselves because the mediator is not imposing his decision upon you. We are writing our own solution. And we tend to follow upon when we are writing our own solution, we tend to have a responsibility on it and we tend to follow on it. So when an agreement finally happens, it doesn't feel like somebody won or somebody lost. It feels like everything finally found a way forward that they can work together.
Right. The solution is not imposed, but something that right actually, and then the parties are also not forced to work on whatever injunction or orders they're given, but they're willing to move forward and put all the baggage behind. That's nice. So the next question that I would like to ask you, mediation has certain features built into it, such as confidentiality, neutrality, flexibility. But IP disputes can be very specific in what they need. Trade secret case needs an extra layer of secrecy. A patent dispute needs someone in the room who actually understands the technology. A brand valuation dispute needs financial expertise. So the question is, are there features that the mediation offers currently enough, or do we need to start customizing the process depending on the type of IP dispute that is on the table?
See, I believe the customization would be the future. The core principles of mediation are very strong, as you said, confidentiality here, neutrality, flexibility. These are exactly why mediation works. But when it comes to particular dispute or, yeah, for example, intellectual property dispute, they often involve highly specialized subject matter. As you said, patent dispute may require technical expertise. A trade secret dispute may require enhanced confidential protocol. A valuation dispute may benefit from having financial expert in the room. I don't think we should change the philosophy of mediation, but I think we should strengthen the framework around it because the process should be flexible enough to accommodate the actual realities of the dispute on the table. So customization is the future, I think.
Right, makes sense. And I think mediation in its core also offers that flexibility to make it
Yes.
more friendlier to different sort of disputes that come. Right. So, when a client comes in for mediation, what are they usually expecting? And does the reality match that? And are people walking away feeling like it was worth it? We have spoken about it, but I think it will be great if you throw some more light about it. Or are there gaps between what mediation promises and what it finally delivers to the clients? And
See, from what I've seen, most clients walk into the mediation room expecting one of the two things. Either they think that it will solve everything immediately, or they think it is a complete waste of their time. The reality, I believe, is somewhere in between. Mediation is not magic. You cannot promise outcome. You cannot say that, okay, you will get exactly what you want to get. But it is incredibly effective when parties genuinely engage with the process. If one party is just coming to waste their time, then mediation will not work. But however, if they are cooperating, then mediation can work as a magic. What surprises many clients from what I've seen is that when they don't settle, even when they don't settle immediately, they often leave the room with much better understanding of the dispute than they actually entered. That clarity, that shift in perspective, I believe, is value in itself.
right, makes sense, right? So let's talk about the work that you're doing right now, especially in Kerala. You've talked about building a real mediation culture in Kerala. Specifically, can you tell us about what's the ground reality there? Do people trust mediation? What kind of disputes are people actually bring to the table in Kerala?
See, mediation always existed in Kerala, but we never termed it as mediation. Like Panchayat, Purbasri. Purbasri is an initiative that is taken by the government of Kerala for the. So it always existed where people sit around a table, sort the matter, let it be neighbor dispute, let it be a boundary issue. So I believe Kerala is at a very exciting stage right now. Through my work with the mediation society, I have seen enormous curiosity around mediation. It is not just from lawyers, it is from the students, it is from the professionals, it is even from the ordinary citizen. The question is no longer whether mediation has a place in Kerala. The question Kerala or KFCC is facing right now is how quickly we can integrate it into mainstream dispute resolution. See, the trust is growing, the awareness regarding mediation and other ADR is growing. The challenge now is to create enough opportunities for people to experience mediation firsthand. Because once people understand the process, they tend to appreciate its value, and that appreciation actually spread. We say word of mouth and all, no? So that word of mouth, that positive word of mouth, actually spread, and it will help make mediation reach better people.
Right. Sounds like we could all actually do well with mediation if it so in Kerala and I think overall India as well. So in your current role at the Mediation Society, you saw about 800 applications for mediation training in just 8 months. You trained 200 people. Who are these people and where are they coming from? And what do you think that number is actually telling us about the curiosity around Indian mediation culture?
See, at the mediation society, we usually prefer senior law students or the law professional. Younger law professionals because the senior law professionals are usually accredited as an MCPC mediator. So we prefer younger law professionals who wants to get accustomed to mediation. But what impressed me was not just the number; it was the diversity. See, as I said before, we saw law students, we saw young advocates, experienced practitioners, even professionals from other fields entirely, even HRs, and people who simply want to learn the conflict resolution skills. To me personally, that says something really important. People are beginning to understand that mediation is not only for mediators. It is for anyone who deals with people. It is for anyone who sits across the table and talks to people. See, when hundreds of individuals voluntarily choose to spend their weekends learning how to communicate better, negotiate better, and resolve dispute better, that's not a trend. I believe there's a genuine cultural shift happening in real time. And I think the future in Kerala, from what I've seen, is very promising.
Right. That sounds like hope it moves beyond Kerala because from our conversation, I feel like uh, mediation could be that one way in which we can resolve disputes
Yes,
without creating more disputes. So it has been really great. I think our conversation has been really enlightening and uh, has thrown light on a lot of benefits of mediation and how IP disputes for sure and how the other disputes as well could benefit from mediation. Uh, just one last question from you is if a law student comes to you tomorrow and said that they want to do what you do, work across mediation and IP, what would you tell them and where should they start?
see, I would tell them exactly something I genuinely wish someone had told me when I started. Stop worrying about building a perfect CV because as law students, we want to build the perfect CV so that we can get better internships, better career opportunities. Do not treat ADR or IPR just as ticking boxes that you can tick on your CV. Focus on building real skill. Learn how to draft, learn how to research, learn how to listen, learn how to communicate with a client sitting across from you who's confused. Learn how to solve their problems, not just argue about the problems. Everything will come later. And because if there's something my own journey has taught me, from being a student trying to find opportunities to handling the trademark matters, become an accredited arbitrator and mediator, to judging area competition, it is that career rarely move in straight line, especially for a lawyer. If you're somewhere in your early part of your legal journey, still figuring out what kind of lawyers you want to be, still feeling like everyone around you seems more certain than you are, I want you to know that what you heard today is not an exception. That uncertainty that you're feeling, that uncertainty that you're living in, that is the beginning of something. It is not a problem to be solved. It is a space to be used. If you're handling different matters altogether, then don't get tired, don't get exhausted. Use it to explore yourself. Go to mediation training if you are planning to litigate. Take the IP brief, even if you think that you are a corporate person. Enter the ADR competition, even if you have never done it before. See, the skills you pick up in those wrong rooms will quietly make you a better person in everything. Because you may not be an IP lawyer in the future, but you will learn what IP is. And one important thing I always tell people is learn to listen. Really listen. We started our conversation with that quote. Before you learn to argue, learn to listen. The law will give you plenty of opportunity to sharpen your argument. What it won't automatically give you is the ability to understand what they actually mean, what is actually at stake beneath the legal position. That understanding is what separates a good technician from a trusted advisor. And it is learnable. So go learn it. Don't wait till your CV looks ready to start showing up. Show up first, the CV will catch up.
Right, that's actually a great message. I hope more and more law students are given that message. I certainly hope somebody had told me that, and not just that, build the perfect CV, get the perfect grades and perfect certifications, because real learning happens in the mess of to figure out things, and anything you learn never goes to waste. That's actually really great, and as lawyers, as advocates, as people tasked with the duty to resolve disputes and solve disputes. Listening and empathy is something that is, yes, you were saying?
And one more thing I want to add is you have to find your people, find the right platform, find the right community. Because I started with a firm that was a one-stop solution where I got exposed to wide range of legal field. So those spaces, in those spaces, take those work seriously and treat it with genuine enthusiasm. Spaces like your platform, for example, IP Press, which exists, I believe, precisely to make sure that students, practitioners, and curious mind have somewhere to go, learn, to stay current, to be part of a conversation that is bigger than one person's career. So find your right people, find the right platform, find the right firm. That is very important.
Right, actually, that goes along with constantly having those important conversations that need to be had in your field. Well, great. Thank you for giving us the opportunity to speak and for sharing all the valuable knowledge and information and advice that you shared today. We were glad to host you and have that discussion. And I hope to all our listeners, thank you for listening and tuning in today to learn about IP mediation and career in IP and mediation and career in the legal field in general. We've all taken so much from this session today, and I'm sure I'm going to be spending the next 2 3 days just processing what I learned from you. So great! And if you liked the podcast today, please do consider giving us a follow on LinkedIn, YouTube, and for keep following us for more such IP updates. Thank you.
The IP Press Podcast. From the pens of IP holics.